Something that no parent would want to see is their kids fight about properties, especially in their older age. And the most common way that we know about to transfer properties to their legal heirs is in the form of a will. Now, what if I tell you that there are several other ways in which you can pass on your property or ancestral property to your next generation, which is part of a broader concept called estate planning. Hi, I am Yashwanthnijagal, a chartered accountant in practice. Before I go ahead with explaining the concept of estate planning, I would like to highlight two things. One is that it is best if you ensure that the estate planning is executed before you get too old, because you don't want the sanity of mind aspect to be questioned in the court of law at a later date. And two, make sure that you transfer only your assets and not your liabilities to the next generation. So the first option is by way of executing a will. This is the most prominent option which is used, at least in India, because executing a will is pretty straightforward and does not involve a lot of legal process. Though this is the most prominent approach, you do need to keep certain things in mind while executing a will. The first one is that try to avoid transferring a single property to more than one inheritor, just to avoid legal disputes or difference of opinion at a later stage. 2. Make sure that the language which is used in the will is as simple and clear as possible to avoid ambiguity or legal disputes. The third thing is, make sure at the time of execution of will, you have at least 2 witnesses in place so that the genuinity of the will cannot be questioned at a later stage in the court of law. The second option is by way of a gift deed to your legal heirs or any of the person whom you intend to pass on the properties. The biggest advantage is that there is no question of legal disputes at a later stage, because the whole property transfer happens as soon as the gift deed is executed. Now, the disadvantage is that you will have to incur certain costs as registration cost at the time of executing the gift deed. The second issue is that as soon as the gift deed is executed, the property gets transferred to the legal heir. This might make you vulnerable at an older age, so make sure that you are taking the right decision when you are executing the gift deed. The third option, and probably the most structured way of doing the estate planning process, would be by way of incorporating a trust. Let me just explain the whole concept to you in as simple language as possible. The person who will be transferring the assets to the trust is basically the owner of the properties, is called a settler, and you get to appoint a trustworthy person who will be in charge of distributing or passing on the assets to the beneficiaries, and he would be called as a trustee. And this could be any of your close friend or relative, and someone whom you can rely upon to ensure that the whole process of transferring the assets happens in a seamless manner. And your legal heirs or any other person to whom you want assets to go to are called as the beneficiaries. Now, the biggest advantage of having a trust is that the chances of a legal dispute is much lesser, because the trust will be a registered entity. A couple of things to be kept in mind with respect to a trust. So, the trustee does not have any kind of interest in the assets of the trust. He is only appointed to ensure that the objects of the trust are fulfilled. And the second thing is, there are several types of trusts, such as discretionary trust, wherein the beneficiaries will not know what are the different assets that are being distributed to them, and a non-discretionary trust where all the beneficiaries know how much assets they are going to get exactly. So the disadvantage is that you will have to incur additional costs on account of ensuring the compliances of the trust on an annual basis is fulfilled, and also any modification to be done to the trust at a later stage will require the approval of all the beneficiaries. The fourth option is a straightforward one. It is called as a settlement deed, wherein all members of the family sit together and come to an understanding of what assets gets transferred to whom and in what ratio. And this settlement deed will be registered to ensure that there are absolutely no legal disputes at a later date. And the fifth option is by way of sale of assets. Now, you will have 2 types of assets. One would be liquid assets and the other would be non-liquid assets, like your immovable properties. Distribution of liquid assets, it is pretty straightforward. However, when it comes to immovable properties, there could always be a possibility of a dispute between your legal heirs at a later date. So I think depending on your situation, you can always choose to sell your assets and distribute the sale proceeds between your legal heirs. One of the disadvantages with this approach would be the liability to pay taxes on the assets liquidated. I think there is no one way of doing the estate planning correctly. It purely depends on the circumstances in which you are and also the equation that you have with your family members, be it your kids or your spouse. So make sure that you understand the psyche of the different members of your family and also the kind of assets that you own, whether it is too complicated to split between the family members or it is straightforward wherein you can just transfer the assets to the respective family member. But make sure that you seek professional advice or guidance when you are executing your estate planning.